This is part 3 of the lecture on free appropriate public education. I'm Dr. George Giuliani from Hofstra University. And when we last left off, we were talking about the Rowley case. And I just want to take a minute to review again what the Supreme Court had said. What was the ruling in the Supreme Court? And again, the Supreme Court identified two areas of inquiry in determining whether a state had met its requirements of a free appropriate public education. First, did the state comply with the procedures set forth under the federal law, Public Law 94-142? Again, was there parental consent? Was the evaluation done correctly? Were the parents involved? Was an IEP developed? And second, was the IEP developed to enable the child to receive educational benefits? And the Supreme Court said that if those two requirements are met, the state or the school district here, the school district has complied with the obligations imposed by Congress, and the courts can require nothing more. So the U.S. Supreme Court overturns the Court of Appeals decision, rules in favor of the school district, holding that the federal law, Public Law 94-142, the Education for All Handicapped Children Act, our nation's federal special education law, it held that it did not require schools to maximize the potential of handicapped children. The Supreme Court found that the standard for a free appropriate public education required educational instruction specially designed to meet the unique needs of the handicapped child, supported by such services as are necessary to permit the child to benefit from instruction. So it wasn't about maximizing the potential of students. We weren't looking to maximize the potential of Amy Rowley. What we were looking to see is, did the education she have benefit her? Was there educational benefit from her instruction? And the Supreme Court stated, we hold that the state satisfies the FAPE requirement by providing personalized instruction with sufficient support services to permit the child to benefit educationally from that instruction. So educational benefit is the key to an appropriate education. So future court decisions, subsequent court decisions interpreted Rowley to mean that IDEA doesn't require schools to provide students with the best education or an optimal education, nor does it ensure that students receive services that enable them to maximize their potential. So the Supreme Court was very clear. It's not the responsibility of special education or school districts providing special ed to provide the best or optimal education, nor to maximize the potential of students with disabilities. Instead, schools are obligated only to offer services that provide students with educational benefit. Again, here's that phrase, educational benefit. Courts sometimes refer to this as the Cadillac versus Chevrolet argument, meaning that the student with special needs is entitled to a serviceable Chevrolet, not a fully loaded Cadillac. So this is a huge decision by the U.S. Supreme Court, because what it is saying is that we're not maximizing the potential of students with disabilities. That's not the purpose of education, to maximize each student's potential. That was never the standard set forth in Congress. Instead, the idea is the IEP, or is the education that we're providing here for the student, providing that student with educational benefit. So again, you get a serviceable Chevrolet. You get a car that will take you to and from school, but you're not getting a fully loaded Cadillac maximizing everything within the car. That's not what the Supreme Court said. So essentially, a free appropriate public education requires that every child with a disability receive an education that is individually tailored to meet his or her needs to benefit from the special education instruction. Again, benefiting from instruction. So it's very important here to note that a free appropriate public education does not require that children with disabilities receive the best educational program available. A FAPE requires only that children with disabilities receive an appropriate educational program uniquely suited to their needs. So an appropriate education does not mean a best education, okay? It's an education that provides benefit to the child. Now, this distinction is extremely important if you're advocating for a child in the special education system. Because if you go into a committee on special education meeting or you're meeting with a school district and you say that the best program for this child with a disability is, the school system can easily dismiss the suggestion because the child is not entitled to the best program. The child is entitled to a program that provides educational benefit for that particular child. So you should always use the phrase, the appropriate program for this child is, to describe the program the parents would like to see implemented. Never say the best program for this child is, because best is not the standard in special education. Appropriate is the standard. So always use the phrase, the appropriate program for this child is. So, in conclusion, the U.S. Supreme Court in Rowley ruled that a free appropriate public education does not require schools to maximize the potential of students with disabilities. Rather, a FAPE is specially designed programs that meets the individual needs of students and allows them to receive educational benefit. Again, let me repeat that point. It doesn't maximize potential special education. An appropriate education provides educational benefit to the child. Now, the lack of a specific definition of an appropriate education in IDEA has led to frequent disagreements between parents and schools regarding what constitutes an appropriate education for a particular student. Again, this is where a lot of the different issues and a lot of the different battles are argued and fought in Committee on Special Education meetings, determining what's an appropriate education. The parents may think what's appropriate is a certain thing, and the school district thinks that's not appropriate. An IDEA is silent as to what specifically constitutes educational benefit. So if an appropriate education provides educational benefit, and the federal law doesn't define educational benefit, that leaves it very open to interpretation in a case-by-case basis. Most courts have found that in order to show a FAPE is being provided, the child must make some educational progress. And a number of courts have struggled with the questions of how much progress is sufficient to show that there's educational benefit, so the standards are still somewhat vague. So ultimately, an appropriate education has to have educational benefit and has to be individually tailored for each student. There's no generic formula that can be applied for what an appropriate education is for a child, and that's why there's so much disagreement in terms of what it means to provide an appropriate education. But perhaps the clearest evidence that an educational program is not providing educational benefit is that the child is not progressing educationally, or is even regressing in the present educational placement. So if you have a child who's not progressing educationally, who is in the 4th grade reading at a 2nd grade level at the first year, and then at the end of the 4th grade is still reading at that level, or is actually regressed back to, say, the 2nd grade level, that could show that what the child is receiving is not appropriate. But an appropriate education should enable a child to make progress in the general ed curriculum as well as advance towards IEP goals. Finally, the last point about a FAPE is with regards to graduation and free appropriate public education. And just very, very quickly, a student receiving special education who then graduates from high school does not have the right to the educational services from the school district beyond graduation. There's no duty of a school district to provide a FAPE to students with disabilities who graduate with a high school diploma. Under the federal law, under IDEA, the school system is only obligated to provide post-graduation educational services to the extent and in the same proportion that it does for students without disabilities. So under the federal law, a school system only has to give post-graduation educational services after the student graduates to the extent in the same proportion that it does for students without disabilities. But once a student graduates, once a student with a disability graduates from high school, that student is no longer eligible for FAPE. And that ends the lecture on free appropriate public education.